Good morning, everyone. Whoa, still some feedback. Hold on. There, that should work better. Good morning, everyone. This is Judge McBurney. I see Ms. Battle and Ms. Kaufman on the session. Can you both hear me?
Yes, Judge. Good morning.
Yes, Your Honor. Good morning.
Great. We also have Ms. New on the call. Who's Ms. New?
I'm the court reporter for the case with Ms. Battle and Ms. Kaufman.
Great. Well, thank you, Ms. New, for joining us. If ever you can't hear what's going on, let us know and we'll try to adjust that.
Great.
All right. We are also streaming live on YouTube. If anyone associated with the case wants to see and hear what's going on, they can log in that way. The courtroom is open. I'm here and Deputy Gordon, we're both here. But we've got Ms. Battle, who I believe represents Ms. Webb, appearing remotely, and Ms. Kaufman, who represents MARTA. And this is case 2020cv341200, Ms. Webb versus MARTA. Ms. Battle, and we're here to talk about MARTA'S motion for summary judgment. Ms. Battle, are you ready to go forward this morning?
Yes, Judge.
Okay.
I did want to ask Ms. Kaufman if she wanted to share and take down.
Yeah, that should be fine.
Should be fine, or
afterwards.
Or yes.
Do I need to decide now, or can I confirm that with my client after? Does it need to be decided right now?
No, I mean, if Ms. Battle is having it taken down, then it's being taken down and you're either going to share in it or not. So maybe you could have that confirmation process underway, but it's not going to prevent us from moving forward.
All right, that sounds good. Ms. Battle, can we talk about it after? I just need to confirm with my client.
I just wanted to bring it to your attention.
Yeah, okay. No, thank you for flagging that, Ms. Battle. All right, so I want to share with you all my understanding, high-level overview of what we're working through today, and then I will turn it over to the lawyers to make the presentations that they want to make. As I understand it, Ms. Webb slipped and fell at Lindbergh Station. She had gotten off a bus and was navigating the station. There was a wet area. It may have been wet and soapy. Either way, it was slippery. There was signage indicating that it was wet. It sounds like it was one of those yellow cone type things. And it sounds like it's undisputed, but again, I'll hear from the parties on this, that a MARTA employee even said something to the effect of either that's soapy or don't go that way. But either way, drew Ms. Webb's attention to the wet area. Ms. Webb nonetheless went through the wet area and then slipped and fell and has brought suit against MARTA for having been injured on MARTA's premises because of the slip and fall that occurred. MARTA is seeking summary judgment on Ms. Webb's claims, and the briefs for both sides, I think, lay out the issues. Ms. Battle, is that a more or less accurate overview of what we're working through today?
Some of it is accurate. The part about the employee saying that it was soapy, I think the soapy part is the issue.
Okay.
Whether it was soapy whether she knew it was soapy on the stairs, and whether she knew that there was another way that she could have gone.
Got it. Okay, and we'll work through that. And I didn't mean to suggest that I knew specifically what the employee said. It sounds like the employee is known and either has provided an affidavit or been deposed. So it's not a mystery what the employee said. My observation was meant to convey that there were a couple ways in which MARTA can point to Ms. Webb having some knowledge about this supposed hazard. One would be the yellow cone, wet area, and then the other would be an employee saying, hey, it's wet over there. wet versus soapy, don't know. We'll talk about that. Ms. Kaufman, anything you want to add just in terms of an overview before we get going?
No, Your Honor, I can do that when I get started, I guess, kind of my brief overview, if that's all right with you.
That's fine. Ms. Battle, how is Ms. Webb? One thing I don't know is, did she break her leg? Is she walking? Is she okay now? I appreciate she was injured as a result, but how is Ms. Webb these days?
It drastically affected her because she did end up having a fracture. So she hadn't been in Atlanta that long. So the place that she worked, she had to stand all the time. So she lost her job. She lost her house, with her apartment. She had to move back home, stay with her daughter for a while.
Where's home?
Home is Louisiana.
Okay. All right.
And she's doing okay, but still having a hard time getting a job because she can't stay in that long.
Okay. I'm going to ask you all to go in a different order today. I appreciate that it is MARTA'S motion, and certainly MARTA needs to make argument. But in reviewing the briefs, to me, it's going to be more helpful if Ms. Hornsby, you go first, because I'd like to understand your responses to the arguments that Ms. Webb isn't in a position to recover because she knew about the hazard, and she also assumed the risk once she saw the cone, and an employee of MARTA had said, hey, danger, basically. I'm not saying that the person said it was soapy or wet or whatever. But to me, having looked at the case law, those are pretty compelling, if not controlling arguments. And Ms. Kaufman can repeat what was in her brief, but I don't need to hear that. I would like to hear, actually, on behalf of Ms. Webb, why it is that equal or superior knowledge isn't the answer here. And if that's not the answer, then why wouldn't assumption of risk be the answer? That's where I'm starting, having digested briefs on both sides.
I understand, Your Honor. And in looking at that, I definitely understand where you're going with it. But in looking at the law, as I looked at it, the real issue here is one, you have to understand that where she was let off on the station, she wasn't in a car or didn't walk and go to the MARTA station. She was let off by the bus. And it let her off in the place that she was supposed to enter. Also, Your Honor, understanding that the second issue is, although she saw the wet floor sign, where it was located was in the very front of where she entered at. Also, her seeing the wet floor sign would have indicated to her that maybe the floor was wet, but she didn't know that the floor was soapy until she was all the way on the floor. And so for us, that was a foreign substance. And that foreign substance is what we are alleging was the cause of her actually slipping.
So let's start with the foreign substance one, but I do want to also explore your contention. I think maybe this is what you're saying, that basically there was no other way for Ms. Webb to go but through the water or soapy stuff. That's not my understanding of the facts, but it seems like you're saying for her to get to where she needed to go, her only choice was to go through the hazard. But let's get to that second. This question about foreign substance, there's case law that refers to water as a foreign substance because floors, surfaces you walk on, should be dry. There shouldn't be anything on them. And I have two questions for you. One is, aren't we already in foreign substance land when there's a sign that says the floor is wet, or an employee says, hey, the floor is wet?
Well, the foreign substance that we're talking about is the soap itself. We're not talking about per se the water, but we're talking about the foreign substance, I mean, the actual soap. And so there's case law, Alderman Foods Incorporated versus, I can't pronounce it, Lagun, 246, Georgia, 620. And one thing it talks about is it says, before an owner can be held liable for a slippery condition on his floor produced by the presence of foreign substance thereon, it is necessary that proof should show that he was aware of the substance and would have known of its presence had he exercised reasonable care. And so what we're saying is that she may have been aware of the water, but she was definitely not aware of the soap until she actually proceeded on. Not only that, Your Honor, but there, after the incident, which is a part of the evidence, defendant actually provided the video that we provided to MARTA, which showed that the substance, because they're trying to say she could have gone another way, but the substance was all over the floors. So they're saying that she could have gone through the elevator, on the elevator, on, some other stairs, some other entrance, but she was let off by MARTA at that part of the station. And when she went through all of that area was soapy. And that was actually, they said or wanted to say that somebody told her, one of the employees in the affidavit claimed that she told her not to go that way. But on the video, you can see that it's another person coming through the same entrance. Nobody is telling him not to go. Nobody is directing him any other way. And you can see that the entire area was wet. And now we know it was soapy also.
So tell me the circumstances of this video being made. I'm confused. I know of its existence. It's hard to play because it's floating around on a disc. And in this day and age, sadly, lots of our computers don't have disk drives anymore or CD players. But if your client had busted her ankle, how is she walking around making a video of the specific scene at the time she slipped and fell?
It was not her who made it. She was also coming in with other employees from her job.
Okay.
So this was not all the case law that MARTA has shown. These people, they were going to the mall, they were going to the store, they were going different places. She was actually coming from her job, going home. So it's not like she could have backed out, went down the street, walked somewhere else, took a cab. That was her route. That was the only way she knew to go. That was where the MARTA bus let her off at. And so for her, that was the way that she had to walk, and there were other employees there. So once she fell, one of the employees, then that's when they noticed that there was somebody actually working on the floor, and they noticed the soapy substance. So that's how the video came about. Judge, also, one thing that I put in my motion was about spoolage. MARTA, all these facts that are kind of going in the air or in dispute really wouldn't have been in dispute had MARTA produced the video. They knew about the incident. The MARTA police came out. Even in the MARTA police's police report that was provided to Your Honor, he said at the end that he gave it to the claims department. So it's common knowledge MARTA has video cameras. everywhere. And we asked them to produce it. They wouldn't, they've not produced it. And the only
You
video-
just went. I'm sorry, you cut out for a minute. You said it's common knowledge that MARTA has video cameras everywhere, and then something about you asked to produce.
Yes, we requested them to produce the video,
Okay.
any videos that they had, and they've not produced it. And so, Judge, we would like for you to take that into consideration, that because they were supposed to preserve that evidence, that you have discretion to, in essence, punish them for not providing that evidence that would have made these facts pretty clear as to what happened during the incident.
Tell me what your theory is as to why the video would be helpful to your case. Because of course, if the video is helpful to MARTA, it's not spoliation. It's something you really wouldn't prefer that gets played. So if the video shows, and I don't think it has audio, it's just video. If the video shows the yellow cone and what looks like a MARTA employee interacting with your client, and your client nonetheless walking into the area that's been described as wet or having water on it, what does the video add that we don't already have?
Well, one, Judge, the video would have added enough information for even me to have made a legal determination as to whether my client had a case. Also, what it would have shown, I mean, if you're talking about benefit to us, it would have shown whether the employee actually came up to my client or anything. It would have shown whether my client actually saw the employees doing work. It would have actually saw whether the soapy substance was visible or not. It would have been able to show all of that.
Your client has already admitted through admissions that a MARTA employee warned her. She's admitted that she knew the floor was wet, and she's admitted that she saw at least one, if not more, wet floor signs. So I guess the video could contradict your client's admissions. That doesn't seem like that's helpful to your case. The one piece that I guess you just identified that maybe the video would have shown, it sounds like it's speculative, would be, could you see bubbles or something that would show that the floor wasn't just wet, but maybe it was an enhanced hazard because you could see soap bubbles. Of course, if you could see soap bubbles on a video, it stands to reason that your client would see the soap bubbles because she's closer to the floor than the camera is. So I'm not disagreeing with you. It's peculiar that there were no videos, and I'm going to give Ms. Kaufman a chance to explain why there aren't and why she thinks it ought not to be a situation of spoliation. But the part I'm wrestling with is what's the evidence that it's helpful to plaintiff's case? Because you can't just speculate. You're free to speculate, but that's typically not a basis to grant a spoliation claim that maybe possibly it was helpful. And so I'm just trying to work through, given all the admissions in this case, put differently, all the undisputed facts, I'm trying to figure out how the video addresses a disputed fact. To me right now, so far in our conversation, the potential dispute, although I haven't heard Ms. Kaufman's answer to it, would be, were there alternate non-hazardous routes for Ms. Webb to take? And beyond that, it doesn't sound like there are disputes of fact. There's this legal issue of, well, does soapiness get us to like an additional foreign substance? Or is there basically notice of a hazard, and maybe when something is wet, it's made more slippery because there was grease and soot on the pavement anyway, and the duty is to let people know it's wet and not it's wet with a slippery factor of 10 because it's a mechanic shop and wet means there's going to be oil or what. And I can read Alderman Foods more closely and sort through that. But I am wrestling with, if you got the video, what it adds to your case or takes away from MARTA'S case.
Well, Judge, one, as you stated, one of their issues is that there were other ways for her to go. I think that the video would have shown clearly what other ways she actually could have gone from her getting off the bus to actually following through. Also, Judge, to me, whether it would have helped us in litigating and determining whether this case should have moved forward, if we had it and we saw that there was soapy substance, then we wouldn't be here right now, because I would have definitely explained to my client, that this is not a case that needs to go forward. So it would help us if there was any issue about attorney's fees, because then we would know and be well informed. But it would also, if there was no, because there is an issue about the foreign substance and the soapiness. And so, if she couldn't see the soap, as they're trying to say that she did see the soap, then if she couldn't see it from the cameras, you couldn't see it, then it would be more beneficial to us to show that she would have known about the wet, but not the actual soapy. And there is case law out there, Judge, that talks about waxes and different oils and stuff that, like for instance, is a grocery store case where there was a slip and fall, and they didn't know that it had been actually waxed with a slippery substance, although there was a wet floor, sign out. And so that would be a different type of foreign substance than the water itself. And that would mean we know that MARTA had superior knowledge that they were using soap on the floors because these were their employees. And so that's what we would be saying, is that they would have had the superior knowledge of the soap being on the floor. And so my client would not have had that superior knowledge.
Do you have cases that you're thinking of beyond the ones in your brief? Or if I dig deeper into the cases you cited in your brief, that'll get me to appellate courts discussing, like you gave the example of the wax on the floor in the grocery store, et cetera. Because I'll do that. I'll make sure that I look through the cases you put in your brief. I'm just wondering, when you're referencing these cases, if you have additional beyond what's in your brief.
Yes, Judge. I have American National Bank versus Howard. That's 117 Georgia Appeals, 834. It's a 1968 case. I have a Hogg versus First National Bank. It's 82 Georgia Ave, 861. It's a 1950 case. And I think I have the Altman Foods first.
You did, yeah. That's in your brief. So I've got that. And like I said, I'll look at the cases in your brief. But you seem to have dug pretty deep in this, and I wanted to make sure if there were other cases that you thought were instructive in this area that you shared them with me. So I got those other two that you just mentioned. Okay. Why don't I let Ms. Kaufman respond to what you said, and then I'll circle back to see if there's anything you have to say in response to what Ms. Kaufman said. And I appreciate I'm sort of flipping this around, because typically the movement would be the one who goes first, but I'm getting a whole lot more out of this by starting with what's the response to the arguments that Ms. Kaufman set forth in her brief. So, Ms. Kaufman, why don't we start? We'll go in reverse order, if that's okay. The spoliation and the videos, what can you say first about why videos weren't provided, if they were requested? And then, given that as of right now, as I understand it, there are no videos provided to plaintiff. Why should that be of no consequence to this litigation?
Yes, Your Honor. So I just, as an initial matter, I think that the bringing up spoliation in a response to a motion for summary judgment is improper. She has not moved for sanctions. She has not fully briefed this. It was kind of a throwaway argument at the end of her response, and we're not even allowed to reply unless we get special permission. This issue has not been, there's been no testimony presented that a video ever existed, that it was destroyed, that it was relevant. This is not something that's been explored, briefed, or properly moved for sanctions, and it would be improper to sanction us when the plaintiff never moved for sanctions or presented evidence in support of spoliation. Nonetheless, I will respond. Yes, video was requested. It was not produced because it was not found. I don't have a good answer for that other than there was no video, no responsive video found, and I did search thoroughly for that. Now, again, there's been no evidence that there was a recording of it or that it was destroyed. I know sometimes somebody viewed a video and there's testimony that a video existed at one point and then it was destroyed. That isn't the case here. There's been no testimony or evidence, and I've seen no evidence from MARTA that a video was seen or properly recorded and ever pulled from the system. So I don't know why it didn't happen. But I'm not aware of a video existing and being destroyed.
So I want to make sure that neither Miss Hornsby, should I call you Ms. Battle, Ms. Hornsby, Ms. Hornsby Battle? I don't want to get it wrong. And I default to Hornsby because that's sort of the family and the firm famous name.
Y'all are gonna all do it, especially in Fulton County. So I am fine with it. Hornsby is my middle name. I did that on purpose.
Okay.
So you're fine.
Okay.
You want.
So I don't want Ms. Hornsby or myself to misinterpret what you just said, Ms. Kaufman. You are saying that as of now, your understanding is that there is no video. If Ms. Hornsby were to do a request for production, and it sounds like she has asked for video, so she's already done that. I'm not saying she didn't. You're saying as of now, there's no video. You're not saying, I believe, because to your point of, hey, there wasn't a sanctions motion filed the way we marched through spoliation. Everyone should read the very, very recent, as in yesterday or day before, Court of Appeals opinion about spoliation and MARTA. Judge Markle, my former colleague, sort of tucked it in a jury charge when it hadn't ever been raised. And there's a way to march through spoliation concerns. I appreciate Ms. Kaufman's point that the motion for summary judgment isn't the proper forum, but it doesn't mean we ignore the point. And so that's why I'm pressing you on this a little bit. You're saying right now, Judge, I cannot get my hands on any video. You are not saying, I believe, that there were no cameras that could have taken down, would have recorded this incident. Do you know as a fact that there were no such cameras, or because this wasn't teed up as a spoliation motion, you haven't done the due diligence that would flow from that kind of motion of, all right, let's figure out where the cameras were they working, how long were recordings kept, who knew that maybe this lawsuit was coming, et cetera?
I have not done all of those things. I have tried diligently to explore all the angles to get this video. And we just don't have it. I don't know for sure. I would have assumed, as the plaintiff would, that there would be a camera that would have been pointed in that direction. I have not confirmed that. I have not gone out. And this is also, I think, 2 or 3 years ago now. So I don't know exactly where the cameras were pointing at that time and whether they would have shown her at the top of the stairs. I would think they probably would have been pointed that direction. I have not confirmed that point. It appears that the videos in that station were generally working at the time. So I have tried to look into that, but I haven't gotten, I don't know what happened. I just know we don't have it.
Okay, I'm not holding you to any of those things other than I needed your thoughts about the spoliation argument. And what I'm taking as your first line of argument is it's really, that's not what happens in a motion for summary judgment. It might be a reason where I would conclude there exists a material issue of fact that could be generated by a charge to the jury that the absence of these videos means that the jury may presume or can presume X or Y or Z. But to your point, Ms. Kaufman, I don't think it would be appropriate for me to conclude as a result of today's presentation that spoliation occurred. But I think it's helpful that Ms. Battle has put us on notice that those concerns exist, and it may well be that we find in our e-filing inbox in the next few weeks a motion to that effect. But it's certainly something to weigh that, gosh, there's no video of what happened. And it does seem like from your research that in theory there ought to have been video, but I hear you that it, for whatever reason, passage of time, mistake, whatnot, that video is not accessible anymore.
Yes,
Go ahead.
Yes, Your Honor. Sorry, I didn't mean to interrupt you. I was going to address another point on that. But that may have been where you're going as far as the relevance. But I would like to address that because regardless of whether there was or wasn't or is or isn't, I mean, there isn't that I've been able to find the video. I do not believe that plaintiff can show that it actually has anything to do with this motion or the dispute, the undisputed facts. And I do want to address the soapiness because
we'll get there. We'll get to soapy.
Okay.
But let's focus on the spoliation piece.
Okay, so I guess the soapy part was, I think that it seemed to be the only real relevance, or one of the only real relevance that Ms. Battle had brought up with whether it would show the floor was soapy and whether she knew. And so I did want to address that, but I can wait on that issue because I again don't think it's helpful, even if the video showed soapiness. I think that would actually hurt her.
Okay, so there were two areas that I jotted down that I felt Ms. Battle had identified the video in theory, because of course we don't know what it would have shown, would be helpful. One was it may have shown soapiness or the invisibility of the soap, which maybe would help plaintiff's claim. But the second, and what I'd like to talk about next, if that's okay, is videos may have shown that there were no non-hazardous ways for Ms. Webb to get from where she was dropped off by the bus to where she needed to go. Because that's the second primary argument that Ms. Battle made was, hey, the only way Ms. Webb could get from point A to point B on MARTA'S property, short of walking out in the streets and going all the way around, et cetera, was through a hazardous space. In other words, it was soapy everywhere. And forget about soapy, it was wet everywhere. And so I'd like you to share with me, Ms. Kaufman, what you think the record shows about the availability of non-wet surfaces for Ms. Webb to traverse to get from where she got dropped off to wherever it was she needed to go. And I'm still not clear if she was trying to get down to the train tracks or she was simply trying to leave the station because she lived near Lindbergh. But wherever she needed to go, I heard Ms. Battle saying that there wasn't a way she could go that wouldn't cause her to go through the hazardous space. In other words, it was non-optional. And I don't know if that changes the analysis. I think it would be hard for me to conclude right now that there's any factual issue around Ms. Webb's knowledge that there was a hazard out there. We've got the degree of hazard, that's soapiness, and I'm saving that for last. And then there is is there a safe way to go? And I don't know what the case law says. If a guest needs to traverse to get to where she needs to go, the only way is to go through a hazard. Does that change the way a court would handle a motion for summary judgment?
Yes, Your Honor. I'd like to address a few different aspects of that argument.
Sure.
So first of all, an important point here is that Ms. Webb walked through the wet floor onto a staircase descending down. The undisputed evidence is that, to go to your earlier point, was that she was going down to the train. So we're not disputing that. She was going from a bus into a MARTA station down to a train. She went onto a staircase and tried to go down a staircase after walking through the water with flip-flops on. She went into a staircase. She has testified that she was aware that there were elevators in the station. That is her testimony, sworn testimony in this case. So she chose to go down a staircase instead of elevators. And that's where she slipped, was as she attempted to descend the staircase in wet flip-flops after walking through this floor. So even if the video showed, and again, there's different cameras. I'm not sure how this one video of one part, it's not like every camera would have been pulled. We wouldn't have seen, even if we had pulled the video that showed the staircase, you would not have seen the entire station. Lindbergh Station is a big station. There are several staircases, which is in the record that plaintiff testified that she knew there were several staircases. She knew that there were multiple escalators, and she knew that there were elevators in the station, more than one. She was aware of that. That's her testimony. And so even if we had a video of this one section of the station, it wouldn't have shown what the rest of the station looked like. It wouldn't and moreover, this is a big station. The entire area was not being cleaned. At the same time, the entire station there, it cleaned in sections. And so the video wouldn't have shown that. It wouldn't have shed any light on the.
Okay, but stepping away from the video and getting to this question of alternate routes, is there anything in the record that, well, I guess your point is, look, what Ms. Webb elected to do, despite knowing that there were elevators, was to go through the wet area and go down the stairs. And so I guess my question is there evidence showing that she could get to the elevators from where she was, or was the only way to the tracks from where she was that one set of stairs? In other words, like, were there walls and fences so that the only way out was the stairs? She had no choice. I appreciate she elected to take the stairs, but that election is much less voluntary if the record shows that the only way down to the tracks from where she was let off by the bus was down the staircase upon which she fell.
Yes, I believe there is evidence to that. I'm looking right now to check the section of the, I believe the affidavits discuss the different sections. If you give me 1 second, I can quote it, but I believe it is here. Yes. So, for example, the affidavit of Laura Santos, who was on the cleaning crew, who was the one that warned her directly, which she acknowledges about the floor. At paragraph 9, she says there were several other entrances to Lindbergh MARTA station, which we were not in the process of cleaning, as well as other staircases, several elevators, and an escalator, and other dry areas of the station, which patrons were using to go down to the train platform and come up to the bus. So there is evidence of the record. That is a sworn affidavit on the record. And then I think Marvin Roberts may have addressed that as well. Let me check and see. Check any other affidavits to see if we discussed that. Yes, there in the affidavit of Trey's Lyons, that's exhibit 5 to my motion. Paragraph 7, my crew cleans one section at a time and marks it off with wet floor signs. Most patrons that come to the station go around the wet floor area. There are other sets of stairs, elevators, and an escalator that can be used to go down to the train platform, as well as other entrances to the station. So that is in the multiple portions of the evidentiary record that there were dry ways she could have gone down, in addition to taking an elevator, and that those were accessible to her.
Okay. Soapy versus non-soapy. What's your, anything you want to say about that? Because Ms. Battle is focusing on, yes, my client knew there was water. I don't know if people said there's water or they said it's wet. It could be wet with grease, I guess, but it's basically this second level of foreign substance, the soap in the water, that maybe made it extra slippery. Yes.
So if I could address that by pointing to certain parts of the evidentiary record. Miss Webb testified in her deposition that she saw the soapy floor at the entrance to the station. And I'm going to read that to you, her testimony, because it's contradictory to what Miss Battle is arguing today. So pages 65 through 66 of her deposition, which is attached and cited in my brief. Question, as you entered the MARTA station prior to your fall, did you look at the floor? Answer, yes, of course. Yeah, I walked through it. I saw it was wet. A little further down. Question, how wet was the floor? Answer, it was pretty wet. Yeah, wet, soapy, it was wet. Question, did you see the water and soap as you were walking through the station before you fell? Answer, before I walked in the station, when I first walked in the station, I slid my card, and what really made me pay attention is because I seen the wet floor sign as soon as I came in the station. That's what really made me pay attention. Question, so you were paying attention and then you saw the floor. Then what did the floor look like after you noticed those signs? Answer, it was wet. You could see a little soap. A little further down. You know how you wash dishes in the sink and you have after suds? Yes, that's what it looked like. That's Miss Webb's sworn testimony in this case. And she's talking about, it's very clear she's talking about when she entered the station. She says multiple times, that's the only time she saw, even though in her video she produced, you could see multiple wet station signs, and there's lots of evidence in the record there were multiple yellow wet floor signs. The only one she admits seeing is the one at the very entrance to the station, the very beginning, as she was sliding her card to get in through the gate. That's where she says in her deposition, that made her pay attention. She looked up and she saw the floor was wet and soapy. Those are her words. And she's talking about the beginning of the station as she's walking in. Now she says, she tries to later contradict that and say, well, I didn't see it right away. Well, I was walking on the floor. Of course you were walking on the floor. There's floor throughout the whole station. Nobody's saying you weren't on the station floor. You were on the station floor as soon as you were at the gate. But at the gate, when you saw that, you said you looked up and saw the soapy floor. That's her words. So that isn't contradicted in the record. There's no contradiction. I mean, you can try to split hairs here, but her testimony is clear. She knew there was soap and she knew there was water.
All right.
And I do want to also just make a point that wax and oil is a different type of substance. It is not, there's no evidence whatsoever in the record that there's anything like wax or oil. This is a light soap. That is the testimony in the record by both her own saying it's after soap suds and the 3 different affidavits attached by the cleaning crew that talk about this is a light soap that was being rinsed off. And I think they even cited it was called like So Simple. It's a very light soap. There were some little bit of soap suds. This is not wax. This is not oil. That is a different thing. And that type of analysis should not apply. This is not a hidden wax that's making the floor slip like soap. And there's no testimony this was like a slippery, wet, oily bathroom floor or something. That's not the case. It's not the type of floor that's on our stations.
Okay. Anything else?
I think, I mean, I want to address the issues that you have questions about, because I think my brief really does like lay out my arguments here. So I'm here to help and answer anything that needs following up on. I'm not going to reread my brief to you.
Okay, I appreciate that. Those were the questions I had. I mean, I started my questions with Ms. Battle, and she provided real helpful responses, and I wanted to give you a chance to talk about those same topics. So I don't have more questions for you. My thought would be to give Ms. Battle a chance to say anything in response to what she just heard from you. Again, I appreciate, I'm flipping the order around. Normally we do it the other way, but this is helping me work in reverse this way. Ms. Battle, do you have anything you want to add to the good points you made about soapy versus not soapy, alternate routes and spoliation?
Sorry.
That's okay.
I said, yes, I do. I was just trying to see what order I wanted to address it. I think initially Ms. Kaufman was talking about the elevators and where the elevators were. But if you look in Ms. Webb's deposition, she just asked her were there elevators in the MARTA station. She asked her whether escalators in the MARTA station. As Ms. Kaufman has stated, Lindbergh is a very big station. So just because she knew that there were elevators in the station, and even with the affidavits, they talk about there were other ways to enter MARTA, other ways to get to elevators, but which is just saying that there's another way to get through. That doesn't mean that that's where the bus let her off. There were other ways, and there was an elevator that she could have gone down where she was let off by MARTA. I just think that's very important, because when the bus lets you off, they're letting you off through their entranceway. And so although she may have known about other entrances, that may not have been, I don't think the question wasn't asked, well, could you have gotten there a different way from where the bus let you off? Like MARTA, if MARTA is so big, the buses let you off where you're supposed to go through. And so the question would have been, are there elevators that she could have gone down where she was let off by MARTA? And even in the video, and Judge, if you need a copy of the video, I know Ms. Kaufman sent it to me a different way. She didn't send it via dish, she sent it via email, where I could just open it up and look at it. So I don't know whether Your Honor would like to see that before you make your ultimate decision. But if you look at it, you'll see where another patron is coming through at the same time, and you'll see that he's coming directly towards the stairs. And so that is where we would say that the videos would have shown clearly the entranceway, whether there were other escalators, elevators in that entranceway where she could have gotten to where she needed to get to.
Thank you for flagging that. I should be able to view the video this afternoon. Ms. Niles is going to get me the disc. If for some reason I can't, because we've figured out a way to get a CD player plugged in here at work. Sometimes either Ms. Niles or I are working remotely and we don't bring our work computers home because they're desktops. But I think I'll be able to watch the video this afternoon. If I cannot, I will certainly reach out to both of you and see if we can get a version sent to us electronically. But don't worry about that. I'll let you know if I can't get the disc into a machine and open and viewed.
So second, Your Honor, we talk about the hazard. And the hazard is not what we're saying is the water. The hazard would have been the soapy part. So the question that, and that is why I provided the affidavit, because, and I know this was COVID, my sister actually did this deposition. I didn't do it. And so, because I think I had court or something going on. And so when I went back and I did ask Miss Webb to explain that, because the way that the question was asked was really almost leading. But she started talking about soapiness because for her, she didn't realize about the soapiness until really after she fell and they saw the video and they saw the guys actually cleaning the store. And so I asked her about that whole issue. And that's why she said afterwards that she didn't realize it was soapy until she already had gotten onto the floor. Soap for her was a big issue after the fall. And I know that because I spoke with her, but that is why I provided the affidavit.
You're talking about an affidavit. Where am I finding that? Is it attached to your brief or your response?
It's attached to my brief and response. And I wanted her to better explain to me what, so that the court could understand that she really didn't know about the soap until after she got onto the floor. And if that entire area is soapy, then how is she supposed to get around anyway? Like, if you don't know about the hazard until you're upon the hazard, was she supposed to back up, go back through the exit, and go where? I mean, because she had to go home. So, you know, if she didn't know about the soap until she got onto the actual platform, how else was she supposed to maneuver? And so the issue is the hazard that we're talking about is the hazard of the soap and the superior knowledge of MARTA knowing about the soap, which is clear from the affidavit of Ms. Santos, which was provided in the defendant's brief. It was number 6, where my cleaning crew put a light soapy substance and sprayed the floor with water. So even they admit that it was a light soapy substance. So yeah, I just believe that, and that's why I wanted to provide her affidavit, because the soapy substance that she saw was not until she got she was already on the floor. So it was already, it was already a danger, and a superior knowledge of MARTA knowing that they had soapy substance on the floor.
But your client, just so I make sure I understand what happened, she didn't fall in, you swipe your card, you get through the gate, you're now in an area, and I'm not taking judicial notice of this, but I happen to go through Lindbergh Station a bunch. There are a bunch of ways down. There are stairs this way and that way. And your client's affidavit said, I was going to go the way I normally go. And no one told me not to go in that particular direction. She says that in her affidavit, I did not realize the floor, had soap on the floor until we were already walking on the floor. To me, there's a big difference between realizing soap was on the floor while you are not yet on the stairs and not realizing there was soap until you are on the stairs. And your client appears to be saying, oh yeah, I knew there was soap before I decided to go down the stairs. Does this affidavit say something different than that?
No, Judge, but I guess what I'm saying is that according to her, there was no other way to get around, to get downstairs except for that way, which is what she's gone every other time.
Where in the affidavit does she say the only way down was the way I went, as opposed to one way that she knows how? Paragraph 10, and it's a little vague. She says there's only one way I know how to get to the train. I don't know if that means one set of gates you go through, but we're confined to what's in the affidavit. I don't see in the affidavit where she is saying there is only one way down. Just there's one way she knows how to get to the train. And I don't know if that means going through those entrance gates or just those stairs. Because she seems to acknowledge there's another way to go in paragraph 13. Hey, if someone had told us not to go the way we were going, we would have gone in some other direction.
Right, Judge, because according to their affidavit of Ms. Santos, she was told not to go that direction.
Okay, and Ms. Webb in an affidavit from June of this year is saying no one told me to go in a different direction.
Correct.
Okay.
And The affidavit of Ms. Santos was March 31st of this year.
Okay. All right, well, that's helpful to work through that affidavit. Anything else?
Your Honor, may I be permitted a brief response?
I just want to make sure Ms. Battle has nothing else.
I think that's it, Judge.
Okay. Ms. Kaufman?
Thank you, Your Honor. I just in reference to what you were just talking about, what Ms. Battle was just talking about, with regard to what she knew, I think that the affidavit is a little vague, but it's clarified when taken into context with her deposition, where she testified more extensively on this issue of what she knew about the station. That is cited and attached to my brief. It's pages 58 through 59. And if I could, just for a brief second, read that to you, where she clarifies that what her knowledge was. Question: at the time of the incident, you knew there were several sets of stairs going down to the platform, right? Answer: yes. Question: at the time of the incident, you knew that there was an escalator going down to the platform. Question: answer: yes. Question: at the time of the incident, you knew that there were elevators that could be taken down to the platform. Answer: yes. So when taken into those two things, her sworn testimony together, it does clarify what her knowledge was.
Okay, so your argument is the way to interpret the affidavit was there was a way I went down and no one told me not to go my way. That may be in tension with what Ms. Santos said, but either way, Ms. Webb is averring, no one told me not to go my way. So I went my way and I tried to exercise care, but it was so soapy and thus slippery, I fell. And your response, Ms. Kaufman, is manyfold, but in particular on this point of knowledge about other routes. The deposition is in tension with the affidavit because in the deposition, Ms. Webb is acknowledging, hey, there were other stairs, I'm aware of that. There were escalators, or at least an escalator, and also elevator.
Yeah, you could see it as intention or with it, or you could see it as clarifying it. So I don't even necessarily think it contradicts it. I think it clarifies what was a bit vague in the affidavit is clarified by her testimony, where she's explicitly asked about other routes and she states that she knew. And I would say the same goes to as far as when she knew the floor was soapy. The affidavit is vague. It says, while Ms. Battle says, at some point in her argument just now, she said she didn't know about the soap until after she fell or was on the floor, but that's not what the affidavit says. Nowhere in the record does that appear. The affidavit says, I understood the floor was wet, but I didn't realize I had soap on the floor until we were already walking on the floor. But again, it's vague. It doesn't say what part of the floor. There's this whole floor from the entrance gate to the steps. And she clarified, it's not really even in tension, it just clarifies in her deposition where she states at the beginning of the floor, when she entered the gate, that's when she knew. We're not saying she wasn't on the floor. She's standing on the floor of the station when she enters the gate. So it's not really even in contradiction. It's just the affidavit's vague and the deposition is explicit as to when she knew. And I think that you already caught on to that. But again, the slip didn't happen on the wet soapy floor she was walking through the station. The slip happened after she walked through that and then chose, having known that she had walked through that in her flip-flops, to go down the stairs. That's when she slipped, when she tried to go down the stairs after having walked. And I think that's an important point where she's talking about, she was already on the floor when she realized the water was soapy. She was at the beginning of the floor, then she walked through it, then she chose to walk down the stairs in flip-flops. And that's when she slipped. And she assumed that risk because she knew what she had just walked through. And that's clear in the evidence in the record. She knew it was wet. She knew she just walked through water and soap.
All right.
Judge, can I just wanted to ask, she said, Ms. Coleman said, did you say page 58 of Ms. Webb's deposition? What you were quoting? Were you quoting page 58?
That's what she said. I don't have the deposition in front of me. I mean, I can get it, but I heard Ms. Kaufman say pages 58 and 59.
Starting at the very bottom of 58, line 24, 25, and then on to page 59, lines 1 through 10.
Okay.
So here's what's going to happen. I should be able to look at the video this afternoon. I've got all the paper filings. I should be able to look at the video this afternoon. If I feel like this is something that is resolvable in fairly short order, Ms. Niles will get an email out to you all, and you don't need to worry about the pretrial order that may be coming due. If this is something that is more complicated, then you may get a different email saying, why don't you do the pretrial order? But I don't know that this will necessarily be a trial because I'm going to need more time with it. But we'll give you guidance via email before the week is out as to what your next steps would be, because I know there is a due date coming up for pretrial order. I don't want you all to invest in that if we're going to delay things while we work through an order on the motion for summary judgment. But I appreciate people's presentations today and the thorough briefing of the issues that have been brought up. It's brought things into clearer focus for me, which is always helpful. And I think that covers things. Ms. Battle, anything else procedurally you want to talk about?
No, Judge.
Okay. Ms. Kaufman?
No, Your Honor.
All right. Well, thank you both. Ms. Kaufman, please do circle back with Ms. Battle about your participation in takedown or not, so everyone can settle up with Ms. New.
Thank you, Your Honor.
Thank you, Judge. May we
All right.
be